Chhattisgarh High Court extends marital rape exception. Why this matters? The Chhattisgarh High Court in a key ruling recently said that marital rape immunity in law extended to Section 377 of the Indian Penal Code that criminalized unnatural sex. Section 375, which criminalizes rape, states that the provision does not extend to sexual intercourse or sexual acts by a man with his own wife when the wife has attained the age of majority. However, Section 377, which outlaws carnal intercourse against the order of nature with any man, woman, or animal, does not contain this exception as it was originally drafted to criminalize homosexuality. The High Court was hearing an appeal filed by a man against his conviction in a case about the death of his wife in 2017. The trial court has found that the wife became ill and died subsequently due to forced physical relationship. It had convicted the man under the IPC section 375, 377 and 304 culpable homicide not amounting to murder. But the High Court reversed the trial court's ruling. IPC section 377, now omitted in the Bharatiya Nyaya Sanhita, was often the only legal recourse for married women in cases of non-consensual sex in marriage. The High Court ruling effectively takes away the recourse, echoing the same concerns that legal experts had when the BNS omitted the provision entirely. The High Court was hearing an appeal filed by a man against his conviction in a case about the death of his wife in 2017. The trial court has found that wife became ill and died subsequently due to forced physical relationship. It had convicted the man under the IPC section 375, 377 and 304 culpable homicide not amounting to murder. But the High Court reversed the trial court's ruling. IPC section 377, now omitted in the BNS, was often only legal recourse for married women in cases of non-consensual sex in a marriage. The High Court ruling effectively takes away the legal recourse, echoing the same concerns that legal experts had when the BNS omitted the provision entirely. In its ruling, the High Court pointed out that Section 375 of the IPC contained the marital rape exception under which a man could be prosecuted for non consensual sex with his wife who had attained the age of majority. It also observed that an amendment was enacted in 2013 to expand the definition of rape, but the exception was retained in a section. The court said that it was a well settled principle of law that if two provisions were inconsistent, then the two cannot stand together and earlier is abrogated by the later. Notably, the marital rape exception is currently under the challenge before the Supreme Court, and the Centre has filed an affidavit in favor of retaining the provision. Regarding Section 377, the High Courts relied on Supreme Court's 2018 judgment that decriminalized homosexuality. The apex court ruling had only read down this provision and not entirely struck it down. Therefore, Section 377 remains on the book, continuing to punish non-consensual unnatural offences. An unnatural offence against the order of nature is understood to include sexual acts that do not lead to procreation, covering, for example, bestiality. The High Court said, following the 28 ruling, if an unnatural offence is committed between two consenting partners, Section 377 IPC is not made out. The court thus held that sexual intercourse or sexual acts by a man with his wife is not a rape, and therefore, if any unnatural sex as defined under Section 377 is committed by the husband with his wife, then it can also be treated. Then it can also not be treated to be an offence. Given the marital rape exception, over the years women have invoked Section 377 for non consensual sex, along with provisions of domestic violence, etc. Section 377 carries a sentence of up to 10 years in jail, even if it did not lead to conviction. The provision was invoked as a starting point to initiate prosecution and leverage some protection under the law. Why is Section 377's omission from Bharati Nyaya Samhita an issue? There is no equivalent for Section 377 in the BNS. Numerous experts have argued that this is an issue as the relation of the law leaves men and LGBTQIA plus individuals without meaningful protection against sexual offences. In November 23, Parliamentary Standing Committee tasked with recommending changes to the BNS before it was enacted said in its report that Section 377 remains applicable in cases of non-consensual carnal intercourse with adults. By deleting it from the BNS, it noted that no provision for non-consensual sexual offense against male, female, transgender, or for bestiality has been made. These concerns were raised because sexual offences under the BNS fall under the chapter titled of Offences Against Women and Child, and from the text of the provisions only envisions men as the perpetrators and women as victims for offences such as rape, sexual harassment, and stalking. It does not consider the possibility of men or LGBTQIA plus persons being victims of such crimes. In November 23, Parliamentary Standing Committee tasked with recommending changes to the BNS said in its report that Section 377 remained applicable in case of non-consensual carnal intercourse with adults. By deleting it from the BNS, it noted that no provision from non-consensual sexual intercourse offense against male, female, and transgender for bestiality has been made. These concerns were raised because sexual offences under the BNS fall under the chapter title of Offences Against Women and Child, and from the text of the provisions only envisions men as perpetrator and women as victims for offences such as rape, sexual harassment, and stalking. It does not consider the possibility of men or LGBTQIA persons who do not identify as women being the victims of such crimes. The Transgender Persons Protection of Rights Act 2019 broadly punishes those who commit harms or injuries or endanger the life, safety, health, or well being, whether mental or physical, of a transgender person. However, it only provides a maximum punishment of 2 years imprisonment. In 2024, Advocate Gulati filed a PIL at the Delhi High Court seeking the revival of Section 377. In August 24, Delhi High Court directed the centre to treat the plea as a representation and decide it as expeditiously as possible, preferably in 6 months. However, the Supreme Court dismissed a similar plea in October 24, ruling that this court cannot direct that particular act constitutes an offence. Such an exercise falls under the parliamentary domain. Prime Minister Dhanya Dhanya Krishi Yojana scheme need aim. Finance Minister Nirmala Sitharaman, while presenting the Union Budget on February 1, announced the launch of Prime Minister Dhanya Dhanya Krishi Yojana. Here's all you need to know. Motivated by the success of Aspirational Districts program, our government will undertake Pradhan Mantri Dhanya Dhanya Krishi Yojana in partnership with states, Sitharaman had said while announcing the program. ADP was launched by Prime Minister Narendra Modi in January 2018. The program aimed to quickly and effectively transform 112 of the most underdeveloped districts across India based on three C's: convergence, collaboration, and competition. Convergence of central and state schemes, collaboration of central and state level nodal officers and district collectors, and competition among the districts through monthly delta ranking. Convergence, collaboration, and competition. Convergence, collaboration, and competition. Convergence, collaboration, and competition. The ADP was announced in January 2018 to transform 112 of the most underdeveloped districts across India based on three C's: convergence, collaboration, and competition. Convergence, collaboration, and competition. The ranking is based on incremental process made across 49 key performance indicators under 5 broad socio-economic themes: health and nutrition, education, agriculture and water resources, financial inclusion and skill development and infrastructure. Pradhan Mantri Dhanya Dhanya Krishi Yojana (PMDKY) will cover 100 districts based on three broad parameters: low productivity, moderate crop intensity, and below average credit parameters. Low productivity, moderate crop intensity, low productivity, moderate crop intensity, and below average credit parameters. Low productivity, moderate crop intensity, low productivity, moderate crop intensity, and below average credit parameters. PMDKY will cover 100 districts based on three broad parameters: low productivity, moderate crop intensity, and below average credit parameters, Sitaraman said. According to sources, the Ministry of Agriculture and Farmers Welfare has been collecting data on these parameters based on which the districts will be identified. Cropping intensity is a measure of how efficiently land is used, and it is defined as the percentage of the gross crop area to the net sown. In simple words, the cropping intensity indicates the number of crops grown on a piece of land in an agricultural year. At the all India level, cropping intensity was recorded at 155% in 21-22. Although the figure greatly varied from state to state, cropping intensity was only 111% in 1950-51. Sources also said the ministry has requested Department of Financial Services and NABARD to share the data on district and district-wise farm credit. According to the finance minister, the program has following five objectives: enhancing agricultural productivity, adopting crop diversification and sustainable agricultural practices, augmenting post-harvest storage at the panchayat and block level, improving irrigation facilities, and facilitating availability of long-term and short-term credit. This program is likely to help 1.7 crore farmers. Although the budget documents do not provide a separate allocation for the scheme, officials said the funds will be drawn from various schemes implemented by Ministry of Agriculture and Farmers Welfare and Ministry of Fisheries, Animal Husbandry and Dairying. According to the officials, the government can make an allocation for the scheme after it is formally approved by the Union Cabinet and before its rollout on the ground. The top 5 IT firms, TCS, Infosys, Wipro, HCL and Tech Mahindra, employ more Indians today than the railways or the armed forces. Similarly, private sector banks have more employees compared with their state-owned counterparts. But India still has a major job challenge beyond services. TCS, Infosys, Wipro, HCL and Tech Mahindra. TCS, Infosys, Wipro, HCL and Tech Mahindra. They employ 15 lakh people, while railways employ 12.52 lakh people. Private sector banks employ 8.7 lakh people and public sector banks employ 7.4 lakh people. India's middle income class after independence was largely created by the public sector. Employment in the public sector stood at 194 lakh and in the organized private sector it was 80 lakh in 1995. The